You know what time it is? It's time for a quick legal update. Hi everyone, welcome back to Law Lenz. My name is Sanam and thank you so much for tuning in today. I know in the last episode I said that it's going to be the last one for the year, but employment law just never sleeps. We've got two major updates that have come out as part of the coalition government coming together and saying in our 100-day plan, this is what we absolutely want to implement before Christmas. And guess what? The first thing that they've axed and scrapped and it's gone is the Fair Pay Agreements legislation. It has been repealed and it has come into effect on the 20th of December 2023, so just a couple of days ago. Now, your rights and obligations under all the other employment legislation still stands. If we turn our minds back to what these were, because over the last year and a bit, we've heard a lot about them, the Fair Pay Agreements were there to allow people to negotiate and bargain for minimum entitlements or minimum terms to employment if they were part of particular industries. So they would be negotiating their rest and meal breaks, or maybe their penalties that they would get if they worked overtime, or whatever it might be. So that's essentially what the Fair Pay Agreements were there for, but they are now gone. So bye to them. Now, when it comes to the major change, which I think will be a great asset, a great benefit to all employers, especially larger employers. I know that we have a very negative outlook on these larger employers when they move into that more medium enterprise space or the large corporations. It's unfortunate because I'm a huge advocate for using trial periods as long as they're done correctly. And with the new changes to the legislation, what the coalition government has done is they have extended this 90-day trial period clause and the usage of the clause to all businesses across New Zealand. This was rushed through Parliament within a couple of days, this bill around trial period clauses now being applicable to everyone. So as of 23rd of December, all businesses can now use a trial period clause for a brand new employee. And the reasoning behind this, and the reason why I'm also very passionate about this clause being used, is because as an employer in New Zealand, you don't get much. And in terms of the laws working for you, a lot of times it will feel like the laws are working against you. And a lot of that can stem from education and knowing when to do a process correctly. But a lot of it is also because the way that New Zealand law is set up is that it's very employee centric. So what the government has said is around 72% of employees in New Zealand, so 72, that's a whopping number, are employed by businesses with more than 20 employees. So that means most of our workforce is actually being employed by larger companies, but the larger companies were not given these protections. Now, we have seen the trial periods change like this every time the new governments come in. This is not new to us, the fact that the trial period is now applicable to all businesses, but it's back, baby, so you might as well use it. So I highly recommend for people to look into using the trial period clauses. Of course, it is very particular and nuanced, and you need to make sure that you meet all of the criteria. It's not just about putting the clause into the contracts. So I will do a separate episode about that so that it can kickstart you for the new year, so that anyone hiring in the new year, because I know there's usually an uptake around March, April time, anyone that's hiring around then, you'll be able to at least refer back to it and make sure that you're compliant. So those are the two updates from me. I'm really excited about the change when it comes to the 90-day trial periods. I hope you have a lovely Christmas and New Year. I hope everybody's taking a well-deserved break. And thank you so much for tuning into Law Lenz. I always appreciate your support. Have a lovely morning, day, evening, night. Thanks, everyone.